You, Mr. Avinash Chun. You speak English? You are in front of me now because you're what?
He's wanted out of Denver, Colorado, is my understanding.
Okay, you want a bond?
Yes,
Okay, so the reason we brought you out here now is because your lawyer is asking me to set you a bond. I don't know. I've never met you before. I don't even know why you're wanted, but couple things.
This is chilling. The judge is basically saying the victims were found in such dire conditions that investigators thought amputation, or even death, was possible. What do you think? Should defendants facing charges involving vulnerable people automatically be denied bond? Drop your thoughts in the comments.
Number one, and my main concern is public safety. Number two, my other concern is if we set you a bond, are you going to go back to the jurisdiction that you wanted from? I don't know. Let's get to know you. So, Day, tell me about him.
So it's 10 pages and I'm trying to read as fast as possible, but my information is limited. It's regarding a
10
negligent.
pages of criminal history?
No, sorry. The affidavit for the probable cause. I just received it as he was being brought up. And so I'm reading this in real time. But
Wouldn't it take more time?
well, I know you have to go to court 3. I can supplement after the original approach, but the warrant was issued out on December 25th. So on Christmas for negligent bodily injury. I'm reading the probable cause. There was a well-being check request on December 16th, where this defendant was in care of 2 individuals, and his negligent care was sufficient enough that when they investigated, they believed the children required or could have had sustained infection, required amputation, or even death. And they found dried blood. They found, hold on, sorry, it's reddish brown stains on items behind the bedroom door. It goes on for some time, but it's generally sort of disarray and injuries all over, malnourishment. But I spoke with the demanding jurisdiction, and they are requesting him be held at no bond until he is returned to the they do want him, and if the court
If there's only one count or 2 counts?
I think there's 2, but they're under 2 different statutes. When I run the the warrant from Colorado, it looks like he's being charged under 2 different statutes, but because I just got the information, I don't have the charging instrument.
Is it negligent homicide or is it negligent?
They're not dead, but it's that the possibility, just because of the despondent state of the living conditions, the 2 at-risk individuals.
Minor children?
Caregiving center operate at the residence.
Which is special needs?
Looks to go on some time, text from November 25th. Oh, here we go. It's 2 adult males with intellectual developmental disabilities. And so vulnerable complainants. And I believe one of the arguments that counsel was bringing for him to obtain a bond was that he takes care of autistic individuals, and obviously him being charged with these felonies, or even 1 felony of vulnerable individuals, it becomes a public safety risk by the nature of what's already happened. And so with it being over a month, and with the conditions of children being, like I said, almost amputation or death, and I can go further into
Any prior criminal history?
No, Your Honor. But the fact that it was for such a long time and due to their state, and so I'm not sure if they were at a point in their condition, like physical or medical condition, is that they were unable to leave. Obviously, that'd be more akin to constructive kidnapping, but I don't know yet because, again, I'm still reading through it.
Constructive kidnapping?
Well, just because if he's malnourished them or deprived them to a point where they're unable to physically capably leave. The well-being check started in November, but I don't think they did a wellness check until December 15th. Again, I don't know. I'm just reading parts of it. And so I don't know to the extent of it before law enforcement was notified.
Yes, Judge. So a couple of things. First, this case is from Adams County, Colorado. My understanding is that my client was in Sydney, Australia, when this warrant came through. He was in Sydney on the day that December 25th, when the warrant came through. He came back to go back to his hometown, And during that period, the warrant came through and he got picked up. So this,
Oh, 'cause I was wondering why he's here in Houston. Are you telling me that he had a flight connecting to
so my
Denver?
understanding is there's no direct flight from Denver to Sydney, so he had to come through Houston. And so on the way out there, the warrant was not issued. And while he's over there, the warrant's issued. He's coming back. He gets picked up for it here in Houston. Now, it's a charge. We went through a whole bunch of stuff. This isn't probable cause court. All that stuff is in Colorado. That's not here. Here, we're talking about a fugitive case, public safety, and whether or not he's going to turn himself into the demanding jurisdiction. So a lot of public safety talk has been going on. If he were over there and we're talking about public safety, it would be rectified by just saying, don't go talk to whoever is playing witness, right? And so that's the jurisdiction that has the authority to do that. Here, we're just trying to see if he's going to go answer for this charge. He hasn't been running from anyone. He got picked up immediately after he came back into the United States. He is not a flight risk. He came back into town. He didn't know this was out there. And so he hasn't.
Notice the defense's strategy here. He's narrowing the focus. He's reminding the court that this isn't about guilt or innocence on the abuse charges, but simply whether the defendant should be held or bonded while waiting for Colorado. It's a smart legal pivot, but do you buy it?
Been running. He hasn't had an opportunity to avail himself to Colorado. He hasn't messed up in your court. He's got no criminal history. He's got family that supports him, that's willing to post a bond for him. He's got skin in the game if you allow him to go turn himself in.
Okay.
Sorry, I'm just reading the kidnapping part. It says, asked if they were allowed to leave the basement. She stated no. Regarding the targets, asked them to go back downstairs when they come up.
Again, Judge, this stuff is irrelevant to whether or not he's going to go turn himself in, whether or not he's been on the run, whether or not he even knew of these charges. If he needs to answer for that, he can't answer it for it here in front of you. Can't argue against that here. That's in Colorado.
So part of what I'm trying to figure out is if they've notified him regarding this warrant, and obviously that's going to play a part if he was notified to return himself and then he went to Australia. Obviously, I'm going to have a few more questions.
You want to like pass it for just maybe 5-10 minutes and take a look?
Yes, Judge.
Do that. Because I've got a couple things to do here and it looks like he doesn't have all the questions answered. Give me just maybe like 5-10 minutes. We can come back and reconvene so that you know exactly, because if I set him a bond, I want you to be absolutely sure of both of you guys.
Thank you,
Please.
Judge.
Okay, thanks. Okay, are you ready?
Yes, sir.
You have Mr. Cook, correct? Come on up, Mr. Cook.
Morning to you.
Hi. You want a chair, Mr. Cook?
He's the part here. It's just, it was getting too long for him, so I'm like, let me move him that way.
Mr. Cook, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail with credit for the 9 that you've already done.
Yes,
You need to understand that this charge will go on your record. It's going to be there for the rest of your life. You get pulled over. First thing officers do, they're going to look at your criminal history. If they smell alcohol on you and they see that you got a prior DWI, it may not go very well for you. So just be very careful next time you get into a car. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never take this off or try to change this. Do you still want to do this?
Yes.
How do you plead to the offense, sir? Guilty or not guilty? I'll find you guilty, sentence you to the agreement. I am going to suspend your license for 90 days. Do not drive until you get a license. Good luck to you. Thanks. Wave. Okay, you ready? Yes, sir. Messiah Mom, come up. Hi, Owen.
Yeah,
Come on up.
I think I have an arraignment on your docket this morning. Last name is Castillo. First name is Roberto.
Did we do it already? Okay, Owen, you ready?
I am.
Okay, Roberto Castillo, come up.
I've been in Montgomery County this morning, so I'm so late.
That's okay. You're not late. Good morning, Mr. Castillo. Sir, you stand charged with the offense of driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
So on January 1st, 2025, at approximately 4 a.m., the officer observed a vehicle traveling eastbound on FM 2920 in Harris County, Texas. The vehicle pulled into a parking lot and then exited the parking lot onto another roadway in an attempt to avoid the officer's patrol vehicle. The officer initiated a traffic stop on Tomball Parkway, and upon contact with the defendant, the driver and sole occupant of the vehicle, the officer observed glossy red eyes, slurred speech, odor of alcoholic beverage, and the defendant stated he had a six-pack of beer approximately 4 hours prior. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused breath. A blood search warrant was signed and executed.
What was the stop for?
Allow me to read the DIMS, Your Honor, to see if he specified. So according to the officer, the vehicle pulled into a parking lot and then exited in an attempt to navigate away, and the vehicle crossed through the parking lot onto another roadway. And that appears to be all the officer put in the DIMS.
Tell me what he did wrong. What code, what transportation code has he violated? What ordinance, statute? Give me something. I mean, I can give you a little bit of time if you
Give me some more
want.
time, Your Honor, so I can look at
Can you
this.
give me 5-10 minutes, Owen?
Sorry, Judge, I have other cases in buildings.
Okay.
I agree with the court. Even if they allege that he was attempting to, if he cut across, there is a violation for cutting across in order to avoid a traffic control device, but they didn't allege that. All they've got is him turning into a parking lot and then back onto another street. So that's not a
If you
law
give us
violation.
like 10 minutes and we can.
Yep, go to it.
Thank you.
All right. Just take a seat. Don't leave. And then when you come back, we'll finish.
Yeah, as far as, yeah, I was, yeah.
I'm back on Mr. Castillo. Let's see here.
All right.
Yes, Judge. So in
Enlighten
regard
me.
to the crossing the parking lot, it was the officer's understanding, I spoke with the officer, that crossing the parking lot is a violation because he crossed right through, and the traffic code that we found is transportation code.
Hold on. Did you take a look at this?
Judge, I'm very familiar with the statute they're quoting.
Okay, what is it?
It's section 545.423. And it's crossing property, and it states that an operator may not cross a sidewalk or drive through a driveway, parking lot, or business or residential entrance without stopping the vehicle. And the officer said that he crossed, according to the DIMS, he crossed straight through onto the public roadway. And speaking with the officer, he repeated that as well, saying that he was at a slow roll and he just went straight through upon noticing the officer. And that's whenever he performed the traffic stop, as he crossed that parking lot.
An operator may not cross a sidewalk or drive through a driveway, parking lot, or business or residential entrance without stopping the vehicle.
Yes, Judge. And as
He
the,
never stopped at all.
correct, and as the DIMS states, the vehicle pulled into the parking lot and exited the parking lot in an attempt to navigate away from the patrol vehicle. So he just entered and exited. He didn't stop.
First, Judge, that statute requires that you're doing it for the purpose of avoiding a traffic control device. There's an additional element.
Really?
Yes, Judge, if you look at the statute.
Hold on. There's only, it says, so that, what I read was A. B says an operator may not cross or drive in or on a sidewalk, driveway, parking lot, visitors, residential entrance at an intersection to turn right or left from one highway to another highway.
In order to avoid the traffic control device.
Correct, but that looks like it's an or. not and, or, unless you show me unless you can show me differently. I mean,
It is an or, Judge. I agree with that. However, may I address another issue?
of course.
If you listen to the dim summary, he says he intended to stop my client to begin with. Then my client, in order to evade him, rolled across the parking lot.
Good.
There's no explanation as to why he started attempting to stop my client in the first place. I recognize, of course, that police have many and multifarious functions, but activating emergency lights and attempting to stop somebody for some unexplained reason.
I didn't hear that.
Well, Your Honor, the DIMS reads,
It's certainly interesting.
it reads different because it says while the officer was patrolling, he observed the vehicle, and it immediately goes into how the vehicle pulled into the parking lot and exited in an attempt to navigate away from the officer's patrol vehicle. And after that point, it says the officer initiated his patrol lights. So he wasn't attempting to stop him at the point that he entered the parking lot. All the officer articulated was that he was attempting to navigate away from his vehicle.
I mean, what it sounds like to me is he sees the officer and just tries to get away. And then the officer sees him do something that's maybe a violation of the transportation code and pulls him over right there. Had he kept driving and just gone straight, perhaps would have never been pulled over. But the virtue of the fact that you go and do that, if there wasn't a violation, I would kick it all day. But I mean, may
I address one other very shortly?
Please.
The way he says in his dim summary, he says, the purpose for crossing is to evade me. He is thinking this man is trying to evade me. And that certainly implies that he was trying to stop the defendant before the defendant started and turned into the parking lot. Otherwise, why would he say he was trying to evade me? In other words, if he's consciously thinking this man is evading me, he's doing something that would lead the defendant to evade.
I agree with you.
So without showing it.
So here's the takeaway: even a small detail, like crossing a parking lot without stopping, can be enough to justify a traffic stop if it looks like you're dodging the law. These fine print statutes often make or break DUI cases. Stick around, because the next case shows just how quickly things can escalate.
Why?
I agree with you, but the fact remains is he went through, and it looks like he may have indeed violated that part of the transportation code. Now, pull the video. If the video shows you something differently, come back and we can do PC again. I'm always happy to revisit it, but perhaps if he would have kept going and not done anything, not done that, he wouldn't have gotten pulled over. If he would have, and nothing had done, there had been no errors, then you know what would have happened.
Understood.
I'm going to find probable cause for now. What was the last name again?
Castillo.
Okay, Mr. Castillo, I'm going to find probable cause. And let me tell you, you speak English, right?
Sir.
And by no means does this mean that you're guilty of this offense. This just means that there's enough to go forward now. That's all it means. You got a great lawyer who will handle the case for you. If there are always any issues, you guys can come back and reapproach and we can go from there. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to revoke your bond. Okay. As long as you have a valid Texas driver license and liability insurance, you may continue to drive.
It's eligible, Your Honor.
Great. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but just stay in contact with Owen. He will tell you when you have to come back to court. If Owen tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. Do you understand?
Yes, sir.
Okay. For now, I'm going to have you sign a release at Victoria. We'll have you get with Maddie for your bond conditions, and then you guys are free to go. Thanks. Of course.
Right this way.
Wow, he just picked up an ag assault. Saw that, huh?
Christopher Duran.
We had a lot of issues with him, Lori. Many, many issues.
You have an arraignment on page 19. Jump them back in line.
No, you can be on probation.
Go straight through.
All right, bring it.
All right, page 19, Lopez, come on up.
Good morning, Mr. Lopez.
Sir.
So you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 31st, 2024, an officer was dispatched to HEB in Harris County, Texas regarding a shoplift that had just occurred. The officer made contact with the complainant. The complainant is the manager of the HEB and observed the defendant Diaz and defendant Lopez walk through selecting merchandise and place items inside of a red HEB bag and communicate with one another and place items inside backpacks they came inside the store with and roll up the red HEB bag and place it on the bottom rack of the cart. Defendant Lopez paid for 3 items left in the cart. Defendant Diaz went inside the bathroom and reemerged after defendant Lopez paid for the items. Neither defendant attempted to pay for the items in the backpacks or the red HEB bag. The complainant locked the produce exit doors and attempted to confront the defendants. The defendants split up with respective backpacks. Defendant Lopez carried the red HEB bag and the defendants ran from the store management and security in opposite directions. Defendant Lopez was identified by his name and date of birth.
Okay. Mr. Lopez, I'm going to find that there's probable cause to go forward with the case. The co-defendant is the co-defendant in our
Judge,
court.
we had him last week.
He's in here? Okay. I'm ordering you as a condition of your bond not to go to any HEB. Do you understand? If I find that you go to any HEB, if I find that you pick up a new case, if I find you have contact with the co-defendant, I'm going to revoke the bond, put you in jail. No more PR bonds. Do you understand?
Your Honor,
What do you do for a living, sir?
already looking for a job. Yeah.
I'll have you fill out an application for an appointed lawyer. I am ordering you as a condition of your bond not to consume alcohol or illegal drugs as well. If I find that you're using, it's not going to go well. Do you understand?
Your Honor.
Judge, you have an important call.